glad everybody could make it today. We're very honored to have Judge Cynthia Becker with us from the combined Simsbury, Avon, Granby, Canton probate court system. Judge Becker was previously judge of the Avon probate court system, and she has her BA from Hobart College, her JD from the University of Connecticut, and she lives in Avon with her children and husband. And I know as probably most of you, have questions about the probate court system, and we thought that the best thing to do to educate everyone is to have someone as knowledgeable as Judge Becker speak. So without further ado, we welcome Judge Becker and look forward to hearing her comments. We do have some handouts which you can pick up at the end of the session. They'll be on the back table. So Judge Becker.
Phone. Everyone can hear me in the back. If you can't hear me at some point, please just raise your hand and let me know. And thank you to John, and Claire for inviting me this afternoon. And it's an honor to be here and to explain probate to you. I see some familiar faces, Attorney Sprania. So if I mess up, let me know, because you know as much as I do about the process. But in any event, it's when people ask me to speak about probate, they'll say, just give us an overview. Well, it's a pretty meaty topic. As John said, each town used to have a court, and then we were consolidated about 5 years ago, and so now the present court for Simsbury also houses Avon, Canton, and Granby, so we're a consolidated district. We're located over at the town hall in Simsbury. So we've tried to keep it a nice, friendly setting, and we really enjoy being in that space. When we say probate, most people think of what happens when someone dies, and that's the majority of the cases that we handle, although we do a lot of conservatorships as well. Other states say conservator. For some reason, we say conservator. It's the same thing. And other states also call it guardianship. Just a quick overview. In addition to those topics, the probate court actually does a fair amount of work with children's matters. We appoint and remove guardians for children. We terminate parental rights. We finalize adoptions. We also do psychiatric commitments, name changes. So we've got a lot of other things on our plate. But in this area of the Valley, we do see a lot of conservatorship and decedents' estates matters. So I was going to focus my comments today on those two areas. So in starting out, my first topic is actually something that we really don't do much with the probate court, but I think it's an important topic to touch on, and it's advanced directives, or as we call them, living wills. And a lot of times there's confusion about a living will as opposed to your last will and testament. There is a very good summary of advanced directives that the Office of the Attorney General for the state of Connecticut has prepared. So for those of you who have a pen, I'm going to give you that site to look up. It's a great, I did not want to reproduce their handout. They do a very nice job of explaining advanced directives. They have forms that they've included. And so if you just Google State of Connecticut, Office of the Attorney General, and living wills, that gets you to the site the fastest. You can go to ct.gov/Attorney General, but it's a lot more clicking to get to the living wills. If you just get the Attorney General's office in there and living wills in Connecticut, it'll bring you right up to this site. They do an excellent job. As I say, they've included forms, but I do think it's important that if you're going to execute forms that have these important decisions involved, that you should go to an attorney and have them prepare the forms for you. They're not expensive, probably not as much as you pay for your cell phone bill each month, and it's money well spent. So while they do have those forms for you to do, it's critical that the forms be executed properly, otherwise they're not valid, and you certainly would not want to go to the trouble of trying to make an advanced directive when it comes to the end of your life decisions and then have it not be valid and end up in the probate court. As much as we like to see folks, it's more important that you try to plan in advance so that things go smoothly for your loved ones at the time when you're incapable of making decisions for yourself. So I tell people we tend to get caught up in the forms, but the fact of the matter is, if your loved one is in a situation where they no longer can appreciate the situation they're in or express their wishes regarding their treatment, it's a hard time for families. It's very stressful. So your loved ones are already under this enormous stress because they have a family member or a loved one who is in bad shape. So we don't want to pour gasoline on the fire. We don't want now to have a big conflict arise as to how to treat our loved one medically or who's going to make that decision. It really is takes a big burden off your loved ones if you can say in advance, I do or I don't want extraordinary measures taken to prolong my life. I do want these people to make medical decisions for me when I can't. Because I find that that does end up in the probate court, the who is the biggest area of contention usually, and well-meaning and well-intentioned children who have great love for their parent, for example, may all disagree as to how things should play out for that parent, either with life support or simply with treatment. And then you have a lot of conflict that arises that is not. It's not a good situation if you're already not doing well and they're worried and upset about your condition. So I can't emphasize enough how important it is that you do some advanced planning. It's minimal cost, and the benefit is huge for your family and for you because you want to make sure that your wishes are honored when you can't express them yourself. So I urge people to check out the website on the living wills. The probate court has pretty limited jurisdiction when it comes to living wills. We don't prepare them. They're a little different than the last will and testament. Our jurisdiction comes into play when there's conflict. So if there's a dispute regarding the meaning or the application of the living will statutes, then the probate court then gets involved. Or if there's an issue about the document itself. The statutes, the laws in Connecticut that set forth the rules about living wills are in Connecticut General Statutes 19A 580. So again, for those of you who are taking notes, that's where you'd find them in the statutes. And the attorneys and the courts are bound by the statutes, and we have to go by those rules. So if there's an issue or dispute regarding those, that's when they end up in the probate court. So we don't have forms that we can distribute, and we can't help people execute those documents. But the court does get involved in limited ways with the living wills. And then probably the most prevalent way the court gets involved is when the living will isn't working. So you've done advanced directives, you've prepared a living will, and either the people that you've named to make the decisions for you can't fulfill their duty, or a institution, a medical facility is not recognizing the validity of the document. So if that document fails, then the probate court gets involved, because the next step when someone cannot communicate their wishes regarding their medical treatment is to appoint a conservator. So we tend to get involved when either there is no living will or the documents that were prepared are not valid for whatever reason. So it certainly is worth it to execute the documents. The best form is the statutory form that the state of Connecticut has put in the statutes, and you can do separate areas, or it's a one-part form. So in 2006, they changed the statutes regarding living wills, and they call them something different now. So now you appoint a healthcare representative instead of a healthcare agent, which was the old terminology. And you have a living will instead of appointing someone as attorney in fact for healthcare decisions. So if you did a living will and it was prior to 2006, it's still valid. However, I do think that it's worth it again, the minimal investment of doing a new living will that's the current form. It's a good form. It's a 4-part form. The form accomplishes several things. It allows you to express your wishes if you are at the end of your life. If your condition is terminal, if there's no hope of recovery, if you're in a permanent vegetative state, if you're on life support. You have an opportunity in that document to say whether or not you want extraordinary measures taken to prolong your life. And many people have strong feelings about that, and family members might feel differently. And it's hard if your parent doesn't want extraordinary measures taken, and you, as the child, want to keep mom and dad going. So again, you need to express, if you have a desire in that regard, to express that in the document. The second part of the document just appoints a substitute decision maker. It says, I may not be terminal or in a permanent vegetative state, but for whatever reason, I can't make medical decisions for myself. I have dementia, I'm unconscious, whatever it is. And so because I can't, I'm appointing someone else to do that for me, a substitute decision maker. And that's the who that tends to be quite controversial in the probate court. So you are telling your family and the doctors, the caregivers, if I can't make a decision for myself, this is who I want to make the decisions for me. And that's, again, a great help to all the parties involved. It cuts down a little bit on the conflict in the families. The third part of the document says that I'm doing this because I don't want to have a conservator if that situation ever arose. But if for some reason this document fails and I need to have a conservator, this is who I want, and a conservator of their person. So again, it's your chance to speak and to express your preference as to who is going to make the medical decisions on your behalf when you can't. And the last part of the document has to do with organ donation. Many people write on their driver's license, they have it indicate whether they're organ donors or not. And the document is a good document because it just is a little more detailed. A lot of people don't realize that if you just check off a box saying general purposes, that you could be a cadaver in a medical school, your organs are donated wherever they're needed. And some people are fine with that, and some people aren't. Some people just want an organ donated to a specific recipient. So this document allows you to be a little more specific if you are an organ donor as to how you'd like that to play out. So the last thing I want to just mention with living wills is that they can be revoked at any time. So that if you are in a situation where you've executed a living will and you say, I don't want extraordinary measures taken, and then you realize that you do, you can orally revoke the document. I had a client once who was in very bad shape. His wife and his son were having a discussion at his bedside about the living will and life, discontinuing life support, and they thought that he, was really out of it, but he was able to write on a piece of paper, I want to live. And so, and he recovered for a short period of time. So you can revoke it at any time. And if you are in a situation, unlike my client who was in bad shape in the hospital, if you do revoke your living will, you need to let the folks know that have copies of it, that you've revoked it. Often people, when they execute a living will give a copy to their doctor. They'll give a copy to the person they're appointing as their substitute decision maker in the will. And so it's important that the doctor and the individual who is named in the living will know that you've revoked it. We tend to not encourage too many copies to go out of the living will, only because you have to make sure you revoke them all later if you're going to change your mind. So that's just some brief comments about advance directives. But I do think it's important, if you're going to embark on making advance directives, that you meet with an attorney. The attorney can talk about lots of other things that come into play with these documents, and it's money well spent. Again, they're usually very reasonably priced, and it's good advice that you'll get. So let's see, I think I covered most of what I wanted to say about those. Are there any questions regarding advance directives? No? Yes?
Are you familiar with the 5 wishes document, and how does that work as well as the Connecticut document?
All I can say is it's important to use the document that Connecticut has prepared if you're in Connecticut. And if you move to another state, you should do your living will over again in the new state. They're a little bit more state-specific than your last will and testament, which you can pretty much, if it's properly executed, take wherever you go. But it's important to do the document that the state where you're living is familiar with, the doctors are familiar with it, the caregivers. It'll minimize confusion when it comes to the document. So I would recommend that you do the Connecticut form if you're in Connecticut. Yes?
If I make a living will and say 10 years down the road, does it have to be revised, updated?
Does that have to be updated? It doesn't have to be. If, for example, in Connecticut in 2006, they changed the statute, but it said right in the statute the old ones are okay. So it would make sense. It makes sense every 5 or 10 years to review your estate plan anyway. But I would imagine that it would be unlikely that a new statute would completely invalidate prior living wills. So that it probably would be valid, but if a new form was created, the old form might create more confusion than the new form when it comes to the healthcare providers. So every 5 to 10 years, you should probably review your estate plan, touch base with the attorney that helps you, say, is there anything new I need to do? But I would imagine it would always be valid. Any other questions? Well, okay, so the living will is a good segue into the conservatorship, which I had mentioned earlier, and how the court gets involved. So in Connecticut, the conservator statutes are in Section 45A. Most of the probate statutes are in Section 45A of the Connecticut General Statutes. The living wills are a little different. As I mentioned earlier, they're in a different section of the statutes, but most probate matters are in Section 45A, and for conservatorships, they start at 644. So it's 45A-644 for those of you that want to look at the statutes. So there are two kinds of conservatorship in Connecticut. There is a conservator of the person, and there's a conservator of the estate. And there's two ways for a conservatorship to get before the court. It can be brought by an involuntary petition or by a voluntary petition. So a voluntary conservator petition involves an individual filing a document with the court that says, I would like you, the court, to appoint this person or these individuals to assist me, either in managing my financial affairs and or in helping me to manage my person, helping me to get to the doctor, to pay, to take my medication, to figure out where to live. So that's the voluntary conservatorship. We love forms in the probate court. We can't do anything without a form. So the whole proceeding starts by you filing a form in the probate court for voluntary conservatorship. All the Connecticut probate court forms are on the court's website. We used to keep them in the court, and they kept changing them, and so now we just download them when we need them. For those of you that are computer savvy, ctprobate.gov is our website for the probate courts in Connecticut, and there's a link for forms. Some of them are fillable. Some of them aren't. You just print them out, and you can handwrite them in. It doesn't have to be too fancy. But the whole process starts with someone filing a petition. And if it's a voluntary petition, again, it's an individual asking the court to appoint someone to oversee their finances or to help them in making medical decisions and living decisions about their person. There's a filing fee. It's $150. But I think it might be going up. I'm not under Governor Malloy's budget, but right now it's still $150. So in any event, the court is required then to have a hearing. The probate courts in Connecticut are statutory courts. The courts downtown, the trial courts, have a little bit more equitable remedies, and they can act a little bit more freely than the probate courts. But we are statutory. We have to go right by the written word, and so the statutes say we have a hearing, we must have a hearing. Not only do we have to have a hearing, but the person, the petitioner, who's asking the court to appoint a conservator for them, also needs to be present at the hearing, because the judge has to determine that it really is a voluntary petition, that someone's not holding a gun to someone's head saying, you have to appoint me as your conservator. So I have to assess that the person is really voluntarily asking me to appoint someone to be their conservator. And they will usually suggest who it is that they want. Every now and then, there may not be someone that they know that can do this for them. In the court, we have a list of attorneys and social workers that have been approved by the probate court administrator to work in the courts, and we can appoint people if necessary. So we'll have a hearing. The petitioner will come in and they will explain to me why they would like to have this person, or it can be more than one person. You can have co-conservators appointed to assist them. Now, whenever I appoint someone as a fiduciary is someone who is handling someone else's finances. Whenever I appoint a fiduciary, I'm required to get a probate bond. A probate bond is like an insurance policy. A surety company will guarantee that if the funds that the fiduciary is managing are misappropriated or mishandled, that the insurance company will make the victim whole and they will go after the fiduciary. Now, in voluntary conservatorships, because you're asking the court to appoint someone that you know and you trust to manage your affairs, you can ask to have the bond excused. And so then in that situation, I don't have to require a probate bond. So that's how a voluntary conservatorship application plays out. And as I mentioned, there's two kinds of conservators. So there's the conservator of the estate and the conservator of the person. The conservator of the estate manages your finances. The conservator of the person has the final decision when it comes to medical decisions, where you're going to live, personal things that affect you. The only time that a conservator of the person can't have the last call is if you have a living will. So you have a living will and you've appointed a healthcare representative to make decisions for you. That healthcare representative is going to trump the conservator of the person when it comes to the medical decisions. And so the conservator will be bound by your living will and the decisions of your healthcare representative. If there is a conflict, though, then it is brought before the probate court, and we have a hearing, and I try and resolve the conflict. But so it's important, even if you have a living will, you can have a conservator, a voluntary conservator. One does not negate the other. So, and again, with the financial piece of it, a conservator of the estate will take control of your assets. So even though it's a voluntary petition because you've asked the court to appoint someone for you, the person that's appointed is answerable to the court for your finances. They have to file an inventory of all your assets. They have to file accountings with the court, stating how they've managed your assets, the expenses that they've paid. So it's not something to be undertaken lightly because you are relinquishing control of your finances, and you're relinquishing your ability to make medical decisions on your behalf. Now, I always instruct conservators that I appoint in my court that they are to defer to the person that they're helping in making those decisions. Conservatorship is not the right to lord over someone and impose your will on them. The conservator's job is to help the person they're appointed for to live their life to the fullest, to accomplish their goals. So if a person is asking me to appoint a conservator because they need help managing their finances so they can stay in their home longer, that's the goal of the conservator. And at any time that there is an issue, there's a conflict, it can be brought before the probate court and we'll have a hearing. It's a fairly informal setting. We have a conference room. There's no bench. I don't wear a robe. But we'll sit down around the table and we'll figure out, hopefully, a solution. I view the probate court really as a place where we can solve problems. So it's not me imposing my will on people. It's not me appointing people to impose their will on other people. It's solving problems for people and trying to, again, assist people to live their lives the way they want to live them, if at all possible, and also be safe and comply with the statutes. So that's a voluntary conservatorship. The other means of bringing a conservatorship before the court is an involuntary conservatorship. And in an involuntary conservatorship, someone else is asking the court to appoint a conservator for a person. And that someone else is required to prove, using the rules of evidence, that the person is incapable of either taking care of themselves, caring for their person, or managing their finances. So again, we have, it starts with an application. It's a different form than the voluntary. We have a few more requirements at our end at the court when it comes to notice. We have to serve a copy of the petition on the person for whom the application's been filed to make sure that they know that someone is trying to deprive them of their liberties. So we're required to serve them with the sheriff, and we appoint an attorney for them. If the person who's the subject of the petition has an attorney that they have a relationship with, then we appoint that attorney. If they don't have an attorney, then we will appoint someone who is not connected in any way to the petitioner or any of the parties involved. We want someone who is going to have only allegiance to their client, the respondent, we call them. So the subject of an involuntary petition is called a respondent. So we appoint an attorney, we schedule a hearing, we have the hearing. The petitioner needs to come in and prove to me that appointing a conservator, that the person's incapable of managing either their financial affairs or caring for themselves, and that the appointment of a conservator is the least restrictive means of helping them. We want to examine every other avenue before we take the step of having a court intervene and appoint someone else. So we look at the living will and at what ways that we can allow this person to remain independent without court intervention. But if there really aren't any alternatives, and I do find that the person is incapable of either caring for themselves and or managing their finances, then a conservator is appointed. And it can be someone that the person knows and has suggested, or it can be, again, in a different party. We always appoint, well, almost always appoint an attorney as conservator of the estate. We need a level of sophistication when it comes to managing people's finances, because the fiduciary has a duty to prudently manage these finances. And so we have a couple of individuals who have a background in finances that we do appoint in addition to attorneys, but often it's an attorney. Now, the respondent, the person who's the subject of the petition, if a conservator is appointed for them, they're now called the conserved person. They bear the cost of the proceedings. So they bear the cost of the payment of the conservator and any other costs associated with the conservatorship. Sometimes if a family member serves, there's no cost. If the person cannot pay for a conservator, they don't have any funds, but for example, they need to get on Title 19. They're in a nursing home, they've run out of their funds, the facility needs to have an application filed for Title 19 so that the Medicaid will pay for the person to stay in the facility, then the Probate Court Administration Fund will pay a nominal fee to attorneys. It's a very low rate. We're very appreciative of the attorneys who are willing to accept those cases. They are not really compensated very well, but we have here in Simsbury a very dedicated group of attorneys who have just helped me out on numerous occasions in these cases, and again gone way beyond the call and are not nearly compensated as they should be for the legal services they've provided. But it's a terrific resource for our community that we have these attorneys who are willing to serve in these cases. In the involuntary, I guess the biggest difference between that and the voluntary is this court's finding of incapacity, that the person's incapable. Both kind of conservatorship, voluntary and involuntary, are reversible. So in a voluntary, the petitioner, the person who asked to have a conservator, can terminate it at any time, but they have to give the court 30 days notice. And the reason they require that is a little bit of a safety net, so that if it really isn't in the person's best interests to terminate it and not have a conservator, it gives a concerned family member or loved one the ability to come into the court and file for an involuntary if they feel that the person would be at risk without the assistance. So, but they send a letter saying, I want to terminate it, and if we don't get a petition for an involuntary, in 30 days it's terminated, and that's the end of it. We do require accountings from people who serve as conservators every 3 years, and we audit those and we have hearings on them. So there is very strict court oversight when there is a conservator when it comes to the finances. In involuntary, a person the conserved person, if they want it terminated, they need to prove to the court that the circumstances that existed at the time the conservator was appointed no longer exist. They now are capable. And happily, there have been times when I've been able to do that, whether it's medical evidence or financial evidence they've been able to present to the court. It's a happy day when we can terminate a conservatorship and people can resume the management of their own affairs. Let's see. There's a couple of things I just wanted to mention, and let's see. There's certain restrictions on a conservator. So when I appoint a conservator, I can give them the full authority to step into the shoes of the person that they are serving and do anything they could do. Or I can limit the conservator and say, well, you only have these duties, and whatever duties I don't give the conservator are retained by the conserved person or the petitioner. A conservator cannot terminate a tenancy or a lease of a person under conservatorship, or sell or dispose of any of their real property, household furnishings, or change their residence without probate court approval. So that applies regardless of whether it's a voluntary or an involuntary proceeding. A conservator has to have probate court approval, and that's so that someone isn't placed in a nursing home against their will and their property's sold and they haven't had a chance to be heard on it. So that was an important change that was made in the statutes several years ago when we revamped the conservator statutes, and it's a very good statute. And let's see, conservatorships to a certain extent can be, we can appoint a conservator for someone who doesn't live in Connecticut but they have property in Connecticut. We can transfer conservatorships. There's a kind of a lengthy statute about that. We have the Connecticut Uniform Adult Protective Act, and that allows courts from other states to talk to probate courts in Connecticut. So we've got an individual who's in Connecticut visiting his niece, and he had a stroke, and he's really a resident of another state. We don't know if he can go back to that state. He can't make any decisions here. So again, that we've had some good changes to the statutes that have allowed us to further help people in kind of unique situations. So I think that's pretty much what I wanted to touch on with the conservatorships. Are there any questions? Yes?
How do powers of attorney fit into this situation?
That's a good question. A power of attorney is revoked by the appointment of a conservator. So if you have a power of attorney in place and I appoint a conservator or a conservator is appointed, it revokes that document. We do look to see if someone has executed a power of attorney when a conservator application comes in. That's one of my first questions, especially on an involuntary. Well, do they have a power of attorney? And if they've executed it, why do you need a conservator of the estate if they've already, the respondent has someone in place that they've appointed to manage their affairs? And again, sometimes for some reason that document, the power of attorney, is not effective and will appoint a conservator. But it's always very relevant that the court knows if there is a valid power of attorney, and also it tells the court who the person would want to manage their affairs, so that if we have an individual, for some reason the power of attorney has failed, the document has failed, and we have a conservator hearing, but I know that they wanted their son John to be their attorney in fact, it's evidence as to their preference for the court when the court's trying to decide who to appoint as a conservator. So does that answer your question? Okay. Yes?
Conservator fees exempt from Title 19 look back, even if it's a family member?
I guess, I mean, if the fees that are paid out as an expense to a family.
The conservator charges for being a conservator.
Yes.
If it's a family member, are those exempt from the Title 19 look back for 5 years?
I'm not an estate planner as far as giving advice. Attorney Sparagna knows a lot about that, but I don't. Any expense, what I can tell you is any expense that benefits the person who's the subject of the petition is usually valid, but whether there is a carve out for family members, unless there is a caregiver agreement, I don't know. I don't know the answer to that. Attorney Sparagna, do you know?
Well, if it's conservator and I think the fees are blessed by the court in that case, then in most cases DSS is going to honor that. They're going to look at it, but they're not going to penalize it. Was that your question?
Yes.
Okay, thank you. Thank you. Anything else on the conservators? Okay. Well, so we'll move on to the next topic, which would be the decedent's estates. So, decedent's estates in Connecticut, we've got two kinds. We have a testate and intestate. And so, in a testate estate, it means the person, the decedent who's passed, had a will. Intestate means they didn't have a will. The way the estates are settled are fairly similar, but there are a few differences, a few different terms that we use. In a will, you have an executor. In an intestate estate, you have an administrator. So you've probably heard those terms in the past. So in Connecticut, if you have a will, a valid will can be executed by a person who's 18 years old or older. They have to be of sound mind. The will has to be in writing, signed by the testator, which is the person who executes the will. That's the term we use, testator. And it's got to be signed by two witnesses. There's an additional requirement in Connecticut, a form called a self-proofing affidavit. So those of you who have executed wills may recall that you sign your will, two witnesses witness your signing of the will. Then there's an additional page with a statement on it by the witnesses saying that you were of sound mind and you were not under any duress when you executed your will. Normally, in court proceedings, the best witness is the person themselves. So if the court is wanting evidence, they want to hear it from the witness directly. But because it's so commonplace to execute wills, and because people tend to move around and they may not live in the same area where they executed their will, an exception was made to allow this sworn statement by witnesses in wills so that we don't have to go track down the witnesses and have them come in and say, yes, they were of sound mind. So we do see wills in the court that people have done on their own, but its execution, like with the advance directives, is very important. If it's not properly executed, then the document can be defeated. So in Connecticut, you have to have two witnesses, and we look for the self-proofing affidavit, which has to be notarized. So if you don't have that, and it's a Connecticut will, it's probably not going to be admitted, and then your estate would be administered under the laws of intestacy. Connecticut's come up with a scheme of how to administer someone's estate when they don't have a will, and they pass it through your bloodline. So if you want to have your estate passed to someone other than your closest blood relative, it's important that you have a will. And again, it's a minimal investment for something that's very important and can have huge financial consequences for your family and your loved ones. So it's very good idea when you do your advance directives to also sit down, if you don't have a last will and testament, to talk about that with an attorney. Now, if you did a will in another state and then you moved to Connecticut, is that a valid will? Well, if it was validly executed in the state where you were living, then it's valid in Connecticut. We might look for the self-proofing affidavit. If the state where you executed the will doesn't have that extra statement, then we'll ask whoever's submitting the will for probate in our court to get a statement from one of the witnesses of the will saying that there was no duress and it was freely executed and the person was of sound mind. But when I get a will from another state, I'll research their execution requirements, and if they required 3 witnesses in that state and they have the 3 witnesses and they've done everything, then that will is valid in Connecticut. So that if you have an older will, you don't necessarily have to redo it just because you've moved to a new state. Holographic wills. Those are wills that are handwritten. And we generally don't allow those in Connecticut unless the execution requirement has been met. If the handwritten will is witnessed properly, and we have the self-proofing affidavit that's acknowledged, then it probably will be valid. Joint wills used to be something from many, many years ago. We don't do those anymore. Each person has their own will in Connecticut. It's very important that you have your original will. I tell people when I do their wills, keep it safe, don't hide it, because then your family can't find it when they need it. But the way a will is revoked is either by physically destroying it or doing a new will and saying I revoke my prior will. So if your will's in the house and it's in the desk drawer and there's a fire and you perish and the will is destroyed, then your will's revoked. You can get a copy of a will admitted if it's a signed copy, but you have to go through some hoops to do that. And so it's not always a given that a copy will be admitted. So it's just a good practice either to let your family know it's in the safe deposit box or it's in the fire box in the hall closet. I wouldn't necessarily show my will once I do it to my family members, just because it tends to almost always result in either a conflict or why are you doing that. And so do your will, keep it private, but put it in a place where it can't be destroyed, but it's accessible. And lastly about the will, if you want to change your will, don't write on it. Don't strike it out. There's something you can do called a codicil, and that's the fancy term for an amendment to a will. If you're changing one or two things, you want a different executor and you want to change that, you probably should do a codicil. And again, have an attorney help you prepare it, because once again, execution is king. It's got to be properly executed with witnesses. So that can be easily prepared. If you have a lot of changes you want to make, you probably should just do a new will. If you go back to the same attorney you used previously, they can probably prepare it fairly easily for you. And because it requires the same execution requirements a codicil does as a will, it's probably the same amount of work. But you can make a change to your will. Just don't write on your original will and strike it out. It just creates problems. It could invalidate that whole section of the will. So it is a legal document. Common law marriage we see sometimes in the probate court. They're not legal in Connecticut. So even though you may have been living with a companion for 30 years, by virtue of the fact that you've lived together and you've blended all your assets, does not give that person the right to inherit from you. Connecticut does not recognize common law marriage. So again, it's important that you do a last will and testament if you want that person to inherit from you. Because if you don't have a will and you die, the laws of intestacy will pass it through your bloodline. So your companion would not inherit. So those are a lot of the issues with wills I wanted to raise. So to start the probate process, we have a form, as usual, and it's either asking to have a will admitted and the executor appointed. Now, you're not executor, even if the will says you are, until the court appoints you. Or to have an administrator appointed because there is no will. And there are all kinds of requirements for the petitioner, the person who files the form with the court, that they have to meet, that they have to show the court that they let all the beneficiaries and the heirs at law, the bloodline, know that they filed the petition, that they sent a copy of the will to everybody. So everyone, there's no sneaking around and trying to kind of slip the will into the court and get appointed. Everybody knows and has an opportunity to be heard. So the court can either set a hearing at that point and everybody comes in. All the interested parties can sign a waiver saying we're good with this person being appointed, we don't have any objection, then I can just admit the will without having a hearing. And we also have something called a streamlined process where we'll send out a notice saying we've received a petition asking to have this will admitted and the executor appointed. If you'd like to have a hearing on it, you an interested party, you need to let the court know by this date. And it's usually a week or two down the road. And if I don't hear from anybody, then I admit the will. When I say admit the will, what I'm doing is I'm signing a decree, a court decree that says this person is now executor of this other person's, the decedent's estate. It's got a court seal on it. We give them additional documents with a court seal as evidence that they now can step into the shoes of the deceased and carry out the terms of the will. I've spoken quite a bit about wills, but sometimes the will doesn't come into play when it comes to probate. So we have three kinds of estates, decedents' estates, in the court. We have something we call the tax purposes only. Now, a probate asset is something that's in your name alone. Your will only passes what's in your name alone. So if you have a joint bank account with your spouse, if the title to your real estate is jointly held or in survivorship, then that's not going to be passed by your will. So some people, when they die, don't have any probate assets. Maybe everything is joint with their spouse. If that's the case, if the title to the car, the bank accounts, the stock, the house, everything is either jointly held or has a named beneficiary, if that's the case, then we have a very short form of probate we call tax purposes only. In Connecticut, just to give you a brief, very brief history, before the courts consolidated 5 years ago, the courts were self-funded by the fees generated mostly by decedents' estates. People would file a tax return for the Department of Revenue Services. They'd file it with the probate court. The probate court would charge a fee based on the information on that return, and that fee funded the probate court system. 5 years ago, there was a mandate by the legislature that the courts consolidate, and in return, that the courts would be funded by the general fund, by tax dollars. So now the fees that the court generates, they send down into Hartford, and now we don't get anything back because they just wiped out our fund. But in any event, unfortunately, fees are going to go up, and that's going to pay for a lot. But the reason that I've gotten into that is because a tax purposes only estate is an estate where you file just a tax return. So when I say tax return, I don't mean income tax. When someone dies, you have to file, either the surviving spouse or an executor administrator have to file a final income tax return for reporting whatever income was earned in the year of death. But we also have an estate tax in Connecticut, and that's the tax return I'm talking about. In Connecticut, if your estate is over $2 million, you will then incur an estate tax. And under the new scheme that was just passed by the legislature, it's pretty hefty. If you're under $2 million, you're okay. If you're over $2 million, there was a cap before this legislative session. You could pass billions, and the biggest probate fee you'd pay is $12,500. That cap is gone, and we've sent out bills for $80,000, $90,000. So that's the reality of the probate fee for estates over $2 million now. Will it change next year? Possibly. But in any event, so you have to file an estate tax return. Now, if your estate's under $2 million, you're not going to owe an estate tax, but there's still going to be that probate fee that's charged by the probate court. So the probate court still is the receiver of that tax return, even though it's really a Department of Revenue Services form. There's two forms, the CT 706, which is for taxable estates that are over $2 million, and the 706 NT, which stands for no tax. So the court receives the tax return, processes it, my clerk puts all the numbers into the computer, and a probate fee is generated. The fee, the calculation of the fee, which we get questions on all the time, is in the statutes. It's slightly complicated, so I don't want to get into it now. But if you want to look it up, it's under the Connecticut Revenue Services section. It's 12-349, around in that area, around the 12-300s. And there's a whole schedule of how the fees are charged. So back to my comment about the three ways you can probate an estate, the first being the tax purposes only. That's when everything is joint, there's nothing solely owned by the decedent. Then all you have to do, you, the surviving spouse, the surviving family member, have to do is file that tax return, the CT, either 706 or NT, with the court. You file that with the court. It has a schedule that has you list solely owned property, which if anything's on that schedule, then you don't have a tax purposes only estate. And the jointly held property, the court will then generate a probate fee. The fee is paid. The court issues documents to transfer title to the surviving account holders or tenants in land, and you're done with probate. You have to file the original will with the probate court because the probate courts are the keeper of original wills. We've kept them from the beginning of the inception of the probate courts. We have a huge mountain of wills, not living wills. There's been some talk about not keeping them anymore, but some wills, I think, is it Shoeless Joe? There's some famous people whose wills, I think it's the only signature they have of his in history. So, wills are historical documents, and thus far we've been able to say they're important enough to preserve. So you have to file the will with the court, but we don't go by the terms of the will. You file the tax return, you pay the probate fee, we give you documents so that you can transfer title, you can go to the town and say the car is in my name alone now, or the house, and you're done. Just one thing I wanted to mention when I talk about assets, probate assets. Generally speaking, probate assets are assets of things of value. So you don't have to list clothes, furniture, unless it's a priceless antique. We generally don't value those because people overvalue them. Just a lot of times your possessions really aren't worth what you think they are, and there's no sense in ramping up the value of the estate, which you're going to pay a probate fee on, if really the items aren't valuable. So, we see bank accounts and cars and, valuable personal property, gun collections and things like that. But you don't need to list every little item of personalty unless it has some sort of significant value. Okay, so the next form, if you're not a tax purposes only estate, you might be something that we call an affidavit in lieu. If, again, remember probate assets are only what's in your name alone. If your probate assets are under $40,000, then there's a short form of probate that you can do called the affidavit in lieu. We love forms, but it's only a couple of forms. So it's again, we go by the terms of the will, but we don't appoint an executor. We take the will. You have to, the petitioner asking the court to settle the estate, have to, affirm that the bills have been paid. And again, it's a shorter form of probate. So if the estate's under $40,000, we can do this short form of probate. If it's $40,000 or over, or if you have real estate. So you might not have, say you only have $10,000, your loved one only had $10,000 in a solely owned bank account, so you think, I can do the affidavit in lieu, the short form of probate, but they have real estate. Then you have to do a regular estate. In order to properly transfer title and create a chain of title, we need to properly probate the estate. So you have a full estate. So over 40,000 and over, or if there's real estate, then we have the regular probate estate where you have to ask the court to appoint the executor in the will, or name an administrator if there's no will, and go through the process. Now, a lot of the grumbling about probate and how long it is, just have to say, a lot of times really isn't because of the court. A lot of times the length is determined by families not getting along or information not being filed, and so the court can process matters fairly quickly. But we are a statutory court, and you got to dot the I's and cross the T's so that we can move the matter along. So the court appoints executors, the court can also remove them. So if there is a problem with the executor that's appointed by the court's bound to appoint the executor named in the will. Give them a chance. If they fail in their duties, if there's a conflict, if they're not being open with the beneficiaries, the other beneficiaries of the estate, if they're not complying with the court's requirements, filing documents in a timely manner, the court can remove that executor. Most wills name a backup. I appoint my son John, but if John can't, then I appoint my daughter Claire. So then the court would look to the backup, and if that person is appropriate, would appoint the backup. If there aren't any backups in the will, then the court will appoint someone else who is appropriate, probably an attorney, again, because there's no sense in reinventing the wheel. There are plenty of attorneys willing to work in our court that know probate very well and can get those documents prepared and filed in a timely manner. And the estate will bear the cost of that. So we appoint our executor or our administrator, take a bond from the administrator because the decedent has not had an opportunity to tell the court, I'm not going to require a bond. This person I'm appointing I trust. We don't know the circumstances, so we generally require a bond to cover liquid assets. No one's going to abscond with the real estate, but if there's a lot of cash in a bank account, that kind of thing, I need to get a probate bond in place to ensure that those assets are protected. And so the administrator will go to their insurance agent and say, I need a $100,000 probate bond. The insurance agent will arrange for that, and a premium will be charged, like you do with your car insurance and your homeowners. And so you're not going to pay $100,000. You might pay a few hundred or $1,000, whatever it is, depending on how big the bond is. You're going to pay a premium, probably an annual premium until the estate is settled. So that's how we protect those assets. All right, so we have invited everybody in that's involved. We've had our hearing. We've either appointed an administrator or an executor, and now it's time to roll up the sleeves and get to work. So the first job of the fiduciary, which would be the administrator or the executor, is to file an inventory with the court. They have to marshal the assets, the probate assets, find out what the person had in their name alone, and file that on a form in the court. Now, they're going to have documents from the court appointing them with the court seal so that when they go to the bank or they go to the broker, they're going to be able to have access to that information. They should be allowed, because they're stepping into the shoes of the deceased and they've been blessed by the probate court, they should be able to get that information. And what they want to give to me is the date of death value. So it might be a month or two out, could be a year or two later when the will's probated for whatever reason or the administrator's appointed. We want to see the date of death value. So that's what's reported on the inventory, and again, it's just the probate assets that are reported on the inventory. So that's the first job. Also, you'd want to open an estate account if you're a fiduciary or executor, so that record keeping is king. If you have good records, things will go fairly smoothly in the settlement of the estate. You open an estate account if you're the executor, and you document every deposit you make, you document every check that you write, and then at the end of the process, I require a financial report, which is a story of what you did when you settled the estate. You should be able to go right through the checkbook and say, I started with this came in, that went out. And so things will go very smoothly. Poor record keeping creates a lot of problems. Good paper is really important. And so I would urge anyone who's going to act as a fiduciary, make sure that you keep good records. If you're a surviving spouse, a lot of times they will just pay, if they're the beneficiary of the estate, they'll just pay out of their joint account and keep track of the payments that they make, but they won't necessarily go out and open an estate account. So while you are serving as a fiduciary, you're going to get bills. Claims, we call them. A claim is an expense that arose prior to death and is paid after death. An example would be a credit card bill, an insurance premium payment, those kinds of things. Those are claims, like fellow that was cutting your lawn or snow plowing your driveway. Those bills are called claims. Asks the fiduciary to indicate who the claimant is, if they paid the claim, and how much they paid. Sometimes the fiduciary might dispute a bill and not want to pay it. And if they get into a conflict with a creditor, the creditor has the right, as does the fiduciary, to bring it before the probate court. We have a claims procedure laid out in the statute to try and resolve disputed claims. So that return and list of claims is an important document. By the way, all this is in the pamphlets that I brought. We've got really great pamphlets prepared by the Office of the Probate Court Administrator that lays all this out for you. And I don't know, for those of you that don't have it, I think there's some in the back of the room. So that's the second task of the fiduciary. You file your inventory and value the assets, and then you pay the claims. And don't forget the taxes. When you're looking at claims, don't forget to file that last income tax return. Make sure the IRS is not fun to deal with with back taxes, and you don't want to get into a situation where at the end of the day you distributed the estate to all the beneficiaries under the will, and then you find out that you overlooked 10 or 20,000 to the IRS. They're not going to be nice about that, and good luck trying to get the money back. So just a little bit of advice when you are determining the claims: make sure that you check on taxes, state of Connecticut and the IRS, and try and get that resolved. Now, if a fiduciary is a layperson, a spouse, a son, a daughter, and they feel that things are getting too complicated for them, that they're trying to resolve a claim with the IRS or a creditor, they can hire an attorney to help them in settling the estate, and the estate will bear the expense of that attorney. So that some people that serve as a fiduciary don't only sign documents, and they have attorneys help them prepare them, attorneys who do that all the time. And so you might be living in another state, retain local counsel. The probate court has the final say on fees. The probate court reviews all fees. Every state is different. In New York, I think there's a fee schedule, and the fee that's allowed to a fiduciary and their attorney is based on the size of the estate. In Connecticut, we have a different rule. It's the fees have to be reasonable in my view, and I am guided by case law. And so I might have an estate before me that's $1 million. It's all cash in a broker account, a couple kids, few bills paid, and it's distributed. Not a lot of work was done. That doesn't really justify the payment of a huge fee, even though there might be a lot of assets. Then I have the $50,000 estate where there was a family-owned business that had to be wound down, and the person might have been on the brink of bankruptcy, and just lots and lots of issues, maybe stepchildren, will contests. So the executor and their attorney might get a much larger fee in that estate than they did in the $1 million estate. So they have to justify to me their fee. And so sometimes when I take a look at it and I say, oh, it looks a little bit high, we'll ask the attorney or the fiduciary to file an affidavit with me listing what they did. And so then I'll say, oh, I didn't realize that there were 10 cars that had to be junked and the title was missing, and there was, there were things that happened that generated a lot more work and time that went into it and that justified a higher fee. So the fees are reviewable by the probate court, and as I mentioned earlier, at the end of the process, this accounting is filed with the probate court, and all the beneficiaries have a right to review that accounting, and if they have an objection to a fee, to come to my hearing and we'll talk about it. So that's the way fees work. I know it's a very hot button issue with people, and there's no definitive answer. It's reasonable, but I think it's a really good system because we do take a good close look, and we can tell if a fee is reasonable or not, and give people a chance to justify their fee. Certainly if people have worked hard, they deserve to be paid. So that's how that works. What else do I want to say? So I already discussed the tax return, but it's kind of like the next thing in line after you work on your return on listed claims. You file that estate tax return, and either it's a taxable estate or it's not a taxable estate, but you got to file that, and we'll send out a bill for the probate fee. It needs to be paid. Sometimes, as I mentioned just a few minutes ago, an estate might be bankrupt or insolvent. And we're seeing a lot more of that in this economy. Certainly with real estate, sometimes the mortgages are far in excess of the value of the real estate. And so, a person passes on, their only asset is a house, it's completely underwater. When it's sold or foreclosed on, there's no money left, it's consumed by the debt. Or just claims, credit card bills that far exceed the assets. They got $10,000 in their bank account and they got $90,000 in debt. That would be a regular estate. Even though the probate assets were only $10,000, we have a procedure in the probate court where we can declare an estate insolvent. So sometimes a spouse will come in and they say, it's insolvent, the creditors are calling me, it's very stressful, I don't know what to do. So we'll say, well, I know only $10,000 was in the bank account, was all that your surviving spouse had. So you can either ignore those phone calls and maybe the creditors eventually will go away, or you can open a regular estate, which is a little more paperwork, but then we can declare the estate insolvent. So during the settlement process, there's a form, and you would fill out the form indicating all the creditors, the amount that they're owed, and the court then has to give notice to all those creditors that there's been an application to have the estate declared insolvent. And so everyone gets notice of a hearing that they can attend to say why they shouldn't be discharged. We almost never have people come. Often, like credit card companies, just want that decree from the court so they can write off the debt. So we'll have a hearing, and again, parties will be noticed, and then the court, if there is no objection or there isn't a sustainable objection, the court grants the application, the estate is declared insolvent, and then that makes the creditors stop, dunning the surviving family members. So that's a kind of a different thing we have, but everyone's circumstances are different, when they pass on. So the court has a lot of different procedures to try and address whatever your circumstances were at the time of your death. So we have, we can declare an estate insolvent. We can also award support for a surviving spouse and their family. So if it's there's going to be a delay, sometimes there's a will contest. Sometimes people are unhappy with the way the decedent or the testator divided their estate. Maybe a surviving child is left out or isn't getting enough, and they are objecting to the admission of the will. And as I mentioned earlier, we have a hearing normally, or we streamline it, and someone says, yes, I do want to have a hearing, and I have a real problem with this will. My dad was not with it at all when he executed that will. My brother made him do that, and I want to have a hearing on it. And we do that quite a bit, and they can be very contentious, drawn out, expensive proceedings, but we do them. And so in the meantime, there might be a minor child or a surviving spouse who is going to be left without any funds to support themselves while we're trying to figure out if we should admit the will or not and appoint the executor. No one can access these funds, and the spouse may not be a beneficiary of the will. So we can award an allowance that's paid to the spouse until the estate, a fiduciary has been appointed or whatever the issue is has been resolved. And it's something, again, in the statutes. The other thing that we can do is if there's going to be a prolonged will contest and bills need to be paid for the decedent, or they have a business that needs to be carried on, and the assets will be wasted if several months go by or no one is in the driver's seat, we can appoint someone called a temporary administrator. Temporary administrator can only do what the court allows them to do. And generally, we appoint them to pay bills, marshal the assets, and address any issues of concern, so that, again, we don't have the oil running out in the house and not being paid, or business not being operated. And so many times we will appoint a temporary administrator, usually an attorney, to act in the place of the administrator or the executor until we can appoint that fiduciary. Let's see. I think that's pretty much in a nutshell how the estates play out. Lastly, I require an accounting. And it used to be we required a final account that was very lengthy, lots of schedules supporting all the information. And recently we amended the document so that you can either file that or something called a financial report. So the financial report summarizes a lot of the financial transactions that took place, but the preparer of the report, the fiduciary, needs to have all the supporting documentation available so that if someone questions it, it's available, but they didn't have to complete all these schedules in a very elaborate final account. And again, the court will have a hearing on that unless all the interested parties sign a waiver saying we've seen it, we're fine with it, please approve it, Judge Becker, and then unless I have an issue with fees, for example, I'll go ahead and approve it. And that's how the estate is closed. Okay, well, thank you so much for giving me the opportunity to speak to you today. Thanks for having me.
Thank you, everybody, for attending, and a special thanks to Judge Becker. I think the insight she has provided was really very, very beneficial, at least to me. And as they say, the mortality rate is approaching 100%. So eventually, we're all going to, our heirs are going to have to deal with it. So again, thank you again, and it's good seeing everybody.
Thank you.